Why do simple marriage green card cases get denied? In this video, we're going to break down why even the most straightforward cases of legitimate couples sometimes get denied. And you'll want to stick around until the very end, where we're going to explain the worst trick the USCIS uses to deny genuine couples their green card and how to avoid it. If you're new to our channel, welcome. This channel helps ambitious professional couples handle their marriage adjustment of status case without having to hire a traditional lawyer. Just know that you don't necessarily need to hire a lawyer if you have a straightforward case. And we'll be talking about what exactly makes a case straightforward in this video. It's no joke, but the USCIS has a really bad habit of denying legitimate couples their rightful immigration benefits. But before we get into why the USCIS denies easy cases and the specific ways they do it, we do need to define, is there such a thing as an easy case? Whether a foreign spouse is entitled to receive a marriage green card basically comes down to three things. First, and most importantly, you must be in a legitimate relationship that was not entered into solely for the purpose of obtaining immigration benefits. Plus, you need to have a valid marriage. Second, you must properly comply with all the USCIS requirements. Essentially, this means properly preparing your immigration application and providing all of the required evidence. And third, you must not have any inadmissibilities. These can be due to, for example, past immigration violations, criminal history, prior deportation or removal orders, health issues, or past fraud and misrepresentation. Now, in contrast, there are circumstances that will present couples with a challenging marriage-based immigration process. A hard case will be one that typically centers around the third requirement, or where they have other specific complications. For instance, if the person has any criminal history, prior immigration issues, some specific health issues, etc. This is where special waivers and other lawyering is often necessary if the couple is even eligible to successfully navigate this process. So ultimately, there's really no such thing as an easy or hard case. Every case is unique and presents its own specific circumstances. However, I will say that you could define cases as straightforward and not straightforward. Straightforward cases are excellent candidates for our marriage immigration method program, while not straightforward cases should always make finding an experienced lawyer a priority. To be completely honest, we sometimes come across couples who have very complicated cases, but they still want to believe otherwise and try to file their case without proper assistance. People often refuse to schedule consultation with an immigration attorney, but in my personal and professional opinion, whether you believe your case to be super straightforward or not, you should definitely invest a couple $100s into speaking with a professional who will evaluate your situation. You might not even know that there is an issue with your case. For complicated cases, it often means speaking to 2 or even 3 attorneys, because sometimes they might tell you completely different things, and some of the information that one attorney shares might be outdated. I mean, it's your entire future, and the green card is such a valuable resource that you definitely do not want to risk it. But let us know with a comment if you agree or disagree. It's an interesting topic, and we would love to hear your take on it. Now, immigrants are often treated poorly by attorneys. Margarita experienced that, and for that reason was very much against them. Now though, being on the other side and seeing how one small fact can complicate everything, we definitely see why it's important to do a very thorough research and explore all of your options. So now that we've broken down what defines a simple case, it's time to discuss why the USCIS denies straightforward cases at all. Now, there's ultimately a few reasons why the USCIS denies simple cases, but let's start with the biggest one. It's because it's the USCIS's position that every single marriage case is fake. Yes, you heard me right. The presumption from the start is that you're trying to defraud the US government and illegally obtain immigration benefits. I know it sounds crazy, but this is the way that the US government is operating to ensure that people don't abuse the system. Now, the problem with this presumption is that it creates a bias that is challenging to overcome. The second issue beyond the USCIS assuming every case is fake is that they actually look for or investigate couples with the intent of discovering information that demonstrates fraud. In other words, they're looking to find whatever they can. That's why we made a video covering the leaked USCIS fraud referral sheet that you can watch here. But basically, this sheet shows you the lens through which they view your case and how they will investigate your relationship. And the most problematic part of this form is the empty boxes at the end, where the officer is able to present any information they find that indicates fraud. While this might be concerning, there is hope and a way to tip the odds of successfully getting through this process without issue in your favor. And that's by preparing a solid case with a completely correct application from the start. You really need to think through the evidence you submit and ensure that it meets the USCIS requirements, as well as quickly communicating the legitimacy of your relationship to an officer who likely sees hundreds and hundreds of cases and who is now looking at your case for the very first time. But you're probably thinking, but you just said they're automatically presuming my case is fake. So how would I possibly do this? It's because of the new USCIS policy of waiving marriage interviews and granting green cards. The USCIS is still sorting through a massive backlog of applications, and as I just mentioned, officers see hundreds, if not thousands, of applications per year. I mean, do you know that they work on the weekends and even conduct interviews on the weekends as well? It's brutal, and please don't be surprised if your interview is scheduled for, 7 a.m. on a Saturday. But basically, there's now a conflict here between their presumption of fraud and their policy of clearing out their backlog. And this means with a properly prepared and well thought out application, you can make the officer's life easier by allowing them to clear your case off their plate, as well as giving them the justification to comply with their policy of clearing out the backlog instead of spending time pursuing the presumption of fraud. Look, if you're an ambitious professional couple serious about preparing a solid merit green card application to ensure you get through this process on the first try and without unnecessary delays, you're exactly the type of couple we admit into our marriage immigration method. With our method, you know all of the tricks on getting through this process as fast as possible. For example, you will know how to attend your biometrics 2 to 3 weeks earlier and thus potentially get your work permit sooner, in addition to actually being guided through your entire immigration journey, all the way through naturalization. You can schedule a free strategy session with us today using the links in the description or the comment section. And by the way, we recently interviewed one of our successful members, and you can hear about their amazing experience here. This will give you a good idea about the service we offer. Finally, now that you know why the USCIS denies simple cases, let's break down the different ways that the USCIS does in fact deny these cases. The first way has to do with the form that causes the most issues for couples. But make sure to keep watching, because at the end of this video, you're going to find out the most common and worst way the USCIS can deny your case. So the first way has to do with the Affidavit of Support, or Form I-864. This is by far the most complicated and confusing form in your entire immigration packet. Due to its complexity and the difficulty in understanding what it requires, plus all of the different scenarios that can happen, it already causes the most requests for evidence to be issued due to mistakes made by couples and their lawyers. But get this, we've had couples in our program who made well over $200,000 in income per year get a request for evidence stating that they did not meet the income sponsorship requirements. Given that an income requirement for a household size of 2 is slightly less than $25,000 per year, these couples definitely should not have received this RFE. But nonetheless, this is the reality of things. And beyond wasting your time and adding additional stress to this journey, if you hire a lawyer, you're gonna have to likely pay additional attorney fees to have them respond to this phony RFE. And if you're handling this completely on your own, now you've either got to figure out how to handle responding to an RFE without making any mistakes, or now consider hiring a lawyer to do it for you. Again, this is why it's so advantageous to have everything you need to successfully navigate this process from the start, and why our program was designed to deliver this knowledge to you, all contained in just one place. But to add to this point, we're seeing more and more cases erroneously denied by the USCIS in these situations, with the agency either claiming that they never received a response to an RFE, or that the response they received wasn't satisfactory. We've never had it happen inside our method, but more and more immigration attorneys raise this issue, which makes me wonder what the hell is wrong with the USCIS, and why do they act so incompetent? Attorneys often speculate that maybe it's to collect additional filing fees, because often instead of filing the denial, couples choose to just refile their case, pay the fees, and wait again. But truly, the mistakes on the USCIS end are on the rise. Maybe they had issues with hiring good adjudicators, but whatever this is, unfortunately, immigrants are the ones paying the price and who get stuck dealing with this for years. Now, the second way the USCIS denies simple cases of real couples is by sending RFEs, or NOIDs, or as they're called, notices of intent to deny, to the wrong or old address. This is really messed up because they essentially prevent you from having an opportunity to respond and overcome the issue. An issue that is often not even there to begin with. Basically, requests for evidence, or NOIDs, indicate the issues the USCIS has with your case and requests a response within a certain period of time to respond. This is your opportunity to overcome whatever issue they present in their letter. But by sending these letters to the wrong address, you obviously don't get it, aren't able to respond, and the USCIS, by their procedures, is now able to deny your application, forcing you to start all over again. Which, by the way, you will not believe how many RFEs, approval notices, and even green cards the USCIS erroneously sends, even to the wrong attorney. It literally happens every day where attorneys would receive a letter from the USCIS, but they don't have a client under that name. It's a complete mess. Here's an important caveat though. This address issue often happens when couples have moved and the USCIS continues to use the old address listed in their file. But this issue can be easily prevented by creating and frequently checking your USCIS online account. There are still attorneys out there who tell couples not to worry about creating an account, but having that account is essential since we see that the USCIS is now trying to do as much as possible through these accounts. For instance, you can reschedule your biometrics appointment for an earlier date there, and you will see whatever the USCIS is sending you in that account as well. Plus, just so you know, the best way to change your address on file is through your USCIS account as well. The USCIS now makes a huge emphasis on you processing it there instead of doing it through Form AR11. So let's briefly cover 4 things you need to do if you move to a new address. We wouldn't be covering it if it wasn't super important. First, change your address inside your online account. But even after you process the address change online, you shouldn't stop there. Second thing you want to do is confirm that your address on file has been changed using Chat or speaking to a USCIS agent on the phone. You may think that filing the change of address would be enough, but from experience, it often doesn't actually register on the USCIS's end. So contacting them is essential to make sure your file is updated. Third, you'll want to set up mail forwarding with the USPS. While the USCIS website says that USPS will not forward USCIS documents, it is just a good practice to increase your chances as much as possible. Either way, you do not want your new mail going to your old address. Plus, signing up for USPS informed delivery is also highly important as you go through your entire immigration process. You want to make sure you know what mail is coming from the USCIS and when, so nothing gets lost. And fourth, if you move, try to speak with the owner or whoever will be occupying your old address to have them notify and/or send you any mail they receive addressed to you from the USCIS. While no guarantee, you should be in the business of maximizing your odds in every way possible. And finally, this is the worst way the USCIS denies legitimate couples, by sending phony or erroneous RFEs to intentionally make this process longer for you. Now, what does this mean exactly? It means despite you sending a completely perfect application, the USCIS can still and often does send a request for evidence. This is not just reserved for Form I-864 like we discussed above. The USCIS has an extremely bad habit of sending unjustified requests for evidence on any part of your application. They're basically wasting your time, adding stress, and waiting you out to see if you quit. Seriously. I mean, it's really sad to say, but many couples don't make it through this process and end up with a divorce, which again makes me wonder if the USCIS does this intentionally. It hurts real couples who just want to start their lives together, but the pressure of dealing with the USCIS for years is real. So aside from preparing an extremely solid application as we mentioned before, here's how to prepare for this. First, this is the biggest reason to document everything you do. Make sure you keep a copy of your entire application packet and everything you submit to the USCIS through unsolicited evidence or in response to RFEs. Documenting everything allows you to become super familiar with your case, which really prepares you for the interview where they have yet another opportunity to make you uncomfortable under that interview pressure. And second, regarding phony RFEs, the best thing to do is respond with everything they need the same day or within a couple of days of receiving the notification in your USCIS online account. You don't necessarily need to wait until you receive the paper notice in the mail, since you will eventually see it inside your USCIS online account under the Documents section, and you can just print it out from there. We always encourage the members of our method to respond as soon as possible, and we still believe that submitting your response online and via mail with a tracking number and proof of delivery gives you more leverage in case the USCIS claims they never received your response. This was a lot. I really hope this video helps you be more prepared and confident to take on this journey. Please give us your feedback in the comments. Hearing from you really encourages us to keep going. Thank you, and we'll see you next week.